Hi, my name is Raj Sharma. I'm the managing partner at Stewart Sharma Harshani, one of Western Canada's largest dedicated immigration law firms. Today I'd like to talk about marriage fraud. And I'd like to talk about marriage fraud both from the perspective of the sponsor, the individual who thinks that he or she has been used in a marriage fraud to bring someone simply to Canada, and from the perspective of the individual, the applicant, who has been accused of marriage fraud. We represent both sponsor and applicant at this office, and I'd like to share with you some of the things that we've observed. The first thing that should be understood is that Canada's government has taken steps to protect sponsors, Canadians, from marriage fraud. And what they've done is they've brought in this new regulation, Regulation 72.1, and that requires the sponsored person to live with their Canadian sponsor for a period of 2 years unless there's been abuse, neglect, or there's children. Now, on a side note, if you feel this individual has committed marriage fraud, or let's say this individual has committed marriage fraud simply to come to Canada, it is no great stretch for these individuals to make false allegations of abuse or neglect simply to stymie removal. The first step for the sponsor who feels that they've been the victim of marriage fraud is to contact Citizenship and Immigration Canada. Provide evidence that the applicant is no longer residing, that there has been a separation, that there has not been cohabitation for more than 2 years. Immigration will take it from there. The responsible immigration officer should convoke an interview or provide an opportunity to the applicant, the sponsored person, to show that they have an exception to Regulation 72.1. If the sponsored person cannot do so, a report may be prepared. That report is called a Section 44 report, and that report is then referred to the Immigration Division. The Immigration Division holds a hearing, and at that time, the sponsored person can challenge the allegations contained in that report. If you are a sponsored person and you are in receipt of either a notice to attend for an immigration interview for a Section 44 report, or that you've received a notice of hearing for an immigration hearing, it is vitally important that you retain experienced immigration counsel, because you are risking or flirting or skirting the loss of your status in Canada. At the Immigration Division, the Canada Border Services Agency officer or hearings officer will present evidence to support that report. The sponsored person can challenge and present evidence of their own, and the Immigration Division will then decide whether the allegations are made out or not. If the allegations are made out, then a removal order will be issued against the sponsored person. If the allegations are not made out, then this matter is set aside and the individual retains their status in Canada. If a removal order is issued, a sponsored person still has the right to appeal that removal order to the Immigration Appeal Division. The Immigration Appeal Division can consider other factors beyond simply the allegations contained in the report. The Immigration Appeal Division can look at factors such as humanitarian and compassion factors, such as establishment in Canada, hardship upon return, best interests of any children affected by this decision. And they can consider all the circumstances of the case. Again, if there's a removal order issued against you and you would like to appeal that to the Immigration Appeal Division, it is important that you contact and retain and instruct experienced counsel that have done this before. If you'd like additional information as to how CSE will assess such allegations, take a look at Operational Bulletin 480 found on the CSE website. I've said this before and I'll say it again. Trying to remove someone from Canada is a little like closing the barn door after the horses have been let out. The best remedy is to prevent, the best way to prevent immigration marriage fraud is to do your due diligence. I see a lot of individuals that go abroad to get married, and they've known these individuals for a very short period of time. There's marriages are done in haste. They don't look at the warning signs or the red flags, and they sponsor someone that perhaps they don't know that well to Canada. And so I guess my best advice to sponsors is to avoid being the victim of marriage fraud is to do your due diligence, take your time, look out for any red flags, and trust your instincts. Even if you're the victim of marriage fraud, and even if your spouse has left you before 2 years has elapsed, you're still on the hook for the 3-year sponsorship undertaking. If the individual that you've sponsored to Canada goes on welfare, then the government may well come after you. With all that being said, the reality is that with the breakdown of relationships, narratives change. If you are an applicant and you feel that you're falsely being accused of marriage fraud, it's vitally important that you retain experienced immigration counsel. If you are a sponsor and you are a victim of marriage fraud, then it's important to document everything and to present the best case possible. Thank you for watching our video. If you have any questions regarding marriage fraud, if you're a sponsor that has been the victim of marriage fraud, or you're an applicant or a sponsored person that has been accused of marriage fraud, please don't hesitate to contact any of the lawyers at Stuart Sharma Harshani.